Hello, Madison County Schools family. My name is Dr. Rachel Ballard, and I have the privilege of being your guide as we briefly discuss our desegregation consent order and how the power of us will guide our way to achieving unitary status. During our time together, we will briefly review history, our desegregation consent order, the green factors, and the role of the Desegregation Advisory Committee, known as the DAC, and how this aligns with our pillars of excellence: transparency, equity, readiness, and advocacy. So come with me as we travel back in time. 128 years ago, in 1896, Plessy versus Ferguson, the ruling of this Supreme Court case upheld a Louisiana state law that allowed for equal but separate accommodations for the white and colored races. It became the legal basis for racial segregation in the United States for the next 50 years. 84 years ago, which was 1940, Southern Black African American schools received 40% of per pupil funding in comparison to white schools. In 1954, 17 Southern and border states and Washington, D.C. required their public schools to be racially segregated. Arizona, Kansas, New Mexico, and Wyoming permitted their local community to racially segregate. At that time, Southern Black African American schools received 60% of their per pupil funding in comparison to white schools. On May 17, 1954, was the famous ruling of Brown versus Board of Education. Education is the very foundation of good citizenship, the ruling stated. The court overturned Plessy versus Ferguson and declared that racial segregation in public schools violated the Equal Protection Clause of the 14th Amendment. To separate Black African American children from others of similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. The court overturned Plessy versus Ferguson and declared that racial segregation in public schools violated the Equal Protection Clause of the 14th Amendment. That same day, on May 17, 1954, Bowling versus Sharp, the court held that racial segregation in the District of Columbia public schools violated the Due Process Clause of the Fifth Amendment. The court ruled that state-sanctioned segregation of public schools was a violation of the 14th Amendment and was unconstitutional. In the wake of the decision, the District of Columbia and some school districts in border states began to desegregate their schools voluntarily. State legislators in Alabama, Georgia, Mississippi, South Carolina, and Virginia adopted resolutions of interposition and nullification that declared the court's decision to be null, void, and no effect. Various Southern legislators passed laws that imposed sanctions on anyone who implemented desegregation and enacted school closing plans that authorized the suspension of public education and the disbursement of public funds to parents to send their children to private schools. In the late 1950s and early 1960s, African American soldiers assigned to Redstone Arsenal moved to Huntsville, Alabama, some with spouses and children. Over time, they began to realize that their children were being assigned to different schools than their white counterparts. Then, in 1963, a desegregation case was opened against the Madison County school system, which then included what we know today as Huntsville City and Madison City schools. The order did not reach unitary status at that time, meaning it did not fulfill the requirements. However, the case was reopened, and over the past several years, the Madison County school system has renegotiated the terms of the order with the involvement of the Department of Justice, DOJ, and the Legal Defense Fund, LDF, and began working towards achieving unitary status. On July 5th, 2022, Judge Heikkila, our district judge, signed the updated consent order. Shortly thereafter, the Madison County Desegregation Advisory Committee was formed, known as the DAC. The consent order established the DAC to advise the superintendent and provide input on the implementation of the terms of this consent order. There are several ways for our community to contact the DAC. The DAC email address is dac@madison.k12.al.us, or you can drop comments or questions in the DAC box outside of any of our schools. The order includes 6 green factors or areas of focus. The first green factor is student assignment. This green factor examines zoning and equitable access to course offerings and programs. We're to provide equitable advanced placement offerings at high schools within our district, ensuring at a minimum each high school offers at least one AP course in each of the 4 content areas of math, English, science, and social studies. This green factor also includes our elementary gifted program. We have developed and implemented a uniform process to identify students who are eligible and to communicate the process to parents. We will continue to provide professional development for all involved in identifying gifted students. We also are to establish and implement a plan to diversify gifted teachers and specialists. With college preparatory and advanced placement, we're to work with teachers, counselors, and school administrators to identify students who have the potential to succeed in college prep or advanced placement courses. We have worked to develop a program of services to support students in college prep and advanced placement courses, including students from groups historically underrepresented in these classes. Prior to course enrollment, each high school will conduct outreach to all students in grades 6 through 12 and their parents and guardians regarding our school's college preparatory and advanced placement courses. And we use a variety of methods to communicate course offerings to parents. The last area of focus in this green factor is discipline. Our district has contracted with a discipline equity consultant to collaborate with us to conduct a comprehensive review of the district's discipline policies and procedures. This includes our district's discipline referral form, our code of conduct, disciplinary sections of individual school student handbooks, and our district's alternative school PACE, their handbook. The consultant will also identify trends of racial disparities in our administration of student discipline and consider underlying causes of such trends of disparities. We have worked to ensure our policies and procedures are uniform among the district's schools, with all students subject to the same rules regardless of race or the school they attend. Our goal is that disciplinary consequences minimize students' loss of instructional time, and that students who do lose instructional time as a result of exclusionary discipline are provided opportunities to make up missed work. The second and third green factors are faculty assignment and staff assignments. This includes minority recruitment, hiring and assignment practices, and our district will engage in a qualified third-party consultant, a faculty equity consultant, mutually agreed upon by the district and the plaintiff parties to provide technical assistance and training on the best practices related to the recruitment, hiring, assignment promotion, and retention of minority faculty and certified staff. Also, our data is made public. After every school board meeting, our demographic data of our staff and faculty is available on the MCSS website. The fourth green factor is facilities. We are to provide equitable facilities to ensure every student has equal access to a quality education, regardless of the facility where the student attends school. We also will provide notice to the plaintiff parties if we propose to construct or close a school, or make any renovations or additions that alter the capacity of a school. The fifth green factor is extracurricular activities. We are to continue providing equitable access to activities such as athletics, the arts, or clubs, and identify and work to eliminate barriers preventing participation. The sixth green factor is transportation. We're to provide maps of all bus routes within the district and also a large shapefile of each bus route the district uses to transport students. The question is Madison County School System the only school system with a desegregation consent order? No. There are nearly 50 school systems in Alabama out of 138 who have a consent order, and over 280 school systems have an order nationally. As we partner with families to meet the needs of the whole child, thank you for your diligence in ensuring all of our students are safe, healthy, engaged, supported, and challenged. With such efforts, our goal is for every student to know they belong. The green factors support us in providing equitable services to all students. As we are on a continuous improvement journey, our pillars of excellence, transparency, equity, readiness, and advocacy will lead our way to achieving unitary status. Through the power of us, all students will know they are welcomed, that they belong, and they will succeed in the Madison County School System.